Law Group. And on behalf of the entire Manor Law Group team, I would love to welcome you to our first virtual, but always annual client meeting. We're happy you could join us today, and you should feel good about taking the time out of this morning to be here. This meeting is an important opportunity to review not just your planning, but to be sure that your planning is still on track to accomplish your goals. There have been a lot of legal changes this year, and our legal team is prepared. So speaking of our legal team, let's go ahead and get to know them a little bit better. So we have attorneys Bob Manor, Kelly King-Penner, and attorney Melissa Dixon. They're all accredited by the Veterans Administration to assist veterans with claims and appeals. Melissa Dixon helps families settle the estates after a loved one's death. Melissa also assists families with estate planning and long-term care planning. Kelly King-Penner was granted the highest rating of superb by the attorney rating service AVO. Kelly is a contributor to the Institute for Continuing Legal Education, where she trained other practicing attorneys. Kelly also serves as the secretary of the National Academy of Elder Law Attorneys, Michigan chapter. Attorney Bob Manor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He is one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among the elder law attorneys in Michigan. He's currently the chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. Now, that's enough about our attorneys. Today's meeting is about you. So this is what we're going to be covering today. And as you can see, we have a lot to go through, but we won't keep you for very long. However, we do encourage you to stay to the end because we do have a chance for you to win a prize. So there are a few things I do want to talk about before we really dive in today. First note, today's session will be recorded. We will send out a replay. Also note, you will be able to ask questions during today's session. Just use the question box. We will save time to go over those questions at the end of the session. Now, in spite of the global pandemic, we have actually been very busy. Particularly, Kelly has been busy chasing around Benny, who is almost 2. For the last almost 2 years, Benny has been our office baby. However, he is going to have to make room for 2 more because Katie, newlywed Katie Murphy, is actually pregnant with twins. So we are expecting those babies in February. And we know Katie is very excited for her babies, but we're also excited to say hello to them too. So we're also going to be saying goodbye this year to Ina Golden. Goodbye and congratulations because she is retiring. So Ina, she has been with us for many years as our elder care coordinator. Throughout those years, Ina has been a blessing to our clients and to our team. For those who needed medical advocacy, help navigating the difficult paths of dementia illness, recovery, or long-term care, Ina has been a guiding light. Ina's vast and varied experience has helped so many of our families get the best care possible for their loved one. She served as a hospital corpsman in the Navy during the Vietnam War. She's also using the GI Bill. She earned her associate degree in nursing from Oakland Community College and later her bachelor degree in nursing from the University of the State of New York. Ina has, over the course of her nursing career, she worked in critical care, pediatrics, emergency medical services, quality improvement, research, and even nursing education. She's a certified emergency nurse, licensed paramedic, a member of the training center faculty for the American Heart Association, and even worked as the injury prevention coordinator at a level 2 trauma center. And she's also co-authored several research articles. So Ina, she has used this passion, this dedication, and this knowledge to help our team. And we've been honored to work with her for many years, and she will definitely be missed. We're very glad that Ina and the rest of our team were able to get together this year for our annual Manor Law Group team trip. Now, normally we go down to Detroit, we spend the day with Cracker Jacks, and we watch the Tigers. But this year, because of the pandemic, we kept it a little more socially distant. We went out to the water of Rifle River. We all managed to stay dry, except for a couple of us. Bob. Speaking of Bob, Bob had a really big year this year for awards and accolades. So he was nominated as a top lawyer by both superlawyers.com and Leading Lawyers, which are both coveted honors from attorneys across the country. This month, if you followed us on social media, you will have seen that October is Breast Cancer Awareness Month. And so we went pink. Not only did we wear pink every Friday, we also went out to the community And if you've also saw our Facebook or just even checked your email, you may have even seen a special story that we put out about Wendy, our very own pink ribbon warrior. We also have a new team member this year. Tom Temple is our paralegal. Tom is a valued support to not just our attorney team, but our entire staff. And he has the best dad jokes. All right, so that's it for our team announcements. I would actually like to pass it now to Melissa, who's going to talk about something that's not always the most comfortable to talk about, but it is so important and necessary.
All right, thank you. What you have in front of you now is a visual that you may remember seeing from last year. We passed this out at our meeting last year. So if you were with us, you've seen it before. Our 6 reasons to contact the Manor Law Group for estate administration. So basically, this is your yearly reminder to make sure that your successor trustees contact us when it's time to administer the trust. So there at the top, it says that estate administration is a difficult and time-consuming process. And what I'd like to clarify is that it can be, but it does not have to be a difficult and time-consuming process. One of the ways to prevent that from being difficult and time-consuming, as listed under number 1, is to make sure that your successor trustees take advantage of that free first meeting. By coming to meet with us, they will no doubt leave having learned something as well as gained options for making that simpler. Under number 2 and 3, there's some statistics for you. 16 months to 2 years and 500 to 800 hours to administer a trust. That may seem extreme, but when you divide that down, it's actually an hour to an hour and a half a day, which is more reasonable than it may seem. In part because a lot of people who've been appointed to be a trustee have never done this before. So it's a little bit more difficult once you realize it and you get, dig into it. But that's why we're here. We can streamline the process and we're expert at this, so we can provide direction on making that simpler and quicker. Numbers 4, 5, and 6 are going to be concerns that your successor trustee will face. So under number 4, where it talks about managing creditors, you may be thinking, well, I don't have any creditors, and that's fantastic. But Michigan law says that we still must publish and put them on notice. And we point that out because under number 5, it talks about avoiding mistakes, and that's a simple one that gets missed a lot. And so that's why we're here, to provide assistance and guidance on avoiding mistakes that could further lead to liability down the line. We also have under number 6, the risk of failure to finish. A lot of times I've met with trustees who come in, 6 months to a year down the line, they're overwhelmed, they're frustrated, there's been a lack of progress, and then people are asking questions. Other beneficiaries or interested persons are wanting to know what's going on. Well, chances are they've hit a little snag or this got to be a little bit more difficult than they thought. And so the big picture here is administering the trust is a process, and there's a right way and there's a wrong way to do it. There are things that can get missed, and that's why we're here. We're here to help avoid mistakes that could further subject the trustee to liability.
Thank you, Melissa.
I just wanted to add a little bit to that. So I know sometimes people think about it from the standpoint of going to the attorney, and they found a good attorney, great, they got their documents, they put them on the shelf, and they think they never have to think about them again. And if you've been with us for a while, that's not the right answer. I mean, if you're here, that's not the right answer, because every year we ask you to pull those out and think about them a little bit. But one of the things I'm not sure that we've done enough of is asking you to talk to your family about it, because it's one of those things that it's so much easier if we're here to help you. We can streamline that process completely and make it so much easier for your family. The whole point of you coming, for a lot of you, I remember, for talking to a lot of you, one of the biggest reasons that you give for doing your planning was to make this simpler for your family. Well, guess what? If you've never talked to them and explained to them, okay, well, there's going to be some things you have to do after my death, and Manor Law Group will be able to help you with that, then the problem with that is they often don't know that or believe that. So we don't have a relationship with the kids sometimes. And so it's one of those things that we really appreciate it, and we really think it'd be in your best interest to accomplish your goals, to talk to your kids about this and say, hey, go to see Manor Law Group after I die. Go, take advantage of that free meeting. Consider hiring them to assist you with the process. It's getting even more, even to this year, it's gotten even more important to get really good advice after your death. And the whole point of this was the same thing as to why you came in originally, which is let's make this simple and easy and make sure that we make the best decisions. But it doesn't end on your death. People think, oh, if I do everything right before my death, then it doesn't end on my death, and I don't need to, the kids don't need to do anything. Or at least that's what the kids think. You may not think that, but we've noticed that when the kids come in, they think, oh, they're just going to come in and get a bag full of cash and leave, and it's all done. And it doesn't work that way. There's still a process. Melissa can make this process so much easier, so much easier, and make sure they have good advice. But sometimes the families aren't prepared for that. And so what we're asking is that you talk to your kids and let them know that there is some things they're going to have to do after you pass away. We can make it much simpler and maybe introduce them to us. And so Savannah's going to talk to you in a couple of minutes about one way that you can introduce your kids to us in the very near future here.
Mm-hmm. Thanks, Bob, and thanks, Melissa. And as Bob mentioned, we do have a really good opportunity for those that you've trusted to be left in charge to know exactly what they need to do, so that when that time comes, there's no guesswork. It's already stressful for them. This at least lets them know what they need to do and to be prepared. So normally we would call this workshop the Successor Trustee Workshop. We're changing that this year. It's the Family Education Workshop. And we're also changing a little bit, just like you've noticed that we're virtual now. We're making this event easier for your friends and family or those that you've left in charge to attend. So we're actually pre-recording and we're making this video available on demand so they can watch it whenever, wherever they want. We know they have busy lives and busy schedules, so this way they can just watch it on their own time. We will have this video posted. It will be on our website no later than Wednesday, November 25th. So if you're all together for Thanksgiving, you can even watch it together as a family.
We've done this training for years. We're expanding it a little bit, but we've done this training for years, but we've always done it live. Well, it's difficult if your executor, your kids are out of state or have jobs or those types of things to come to that successor trustee or family education workshop. But it's so important because they need to have some idea of what to expect if you get sick. They need to have some idea of what to expect and what to do after you die. And we can give them kind of clear instructions to say, okay, don't panic if mom or dad has a fall or if there's a medical emergency or something like that. We've already have those legal things in place. We've seen many times where the family caused themselves all kinds of grief because that was unnecessary, because they start court paperwork or they go try to track down a new attorney when they have perfectly good and probably better legal documents that are already prepared and that you've already taken care of things for them, but the family doesn't know it or understand it. Maybe that you told them, hey, one of the things that a lot of parents will say is, it's all under control. I've got everything taken care of. I went to Manor Law Group. I got everything taken care of. That's not enough. And you don't have to explain what each and every document is. We've got a sample document here. You don't have to explain what everything in that binder is. We'll do that for you. But it's great to have an opportunity to talk to the people that will be in charge if you get sick, talk to the people that will be in charge if you die. And one other thing to think about, if you go to your kids and say, okay, now Manor Law Group's made this really easy. You can watch it on Black Friday, the day after Thanksgiving, or you can watch it at 3 a.m. in the morning. You can watch it, just watch it. And if your kids aren't willing to put that effort in to spend an hour just kind of learning what to do in an emergency or what to do, if there's a death, maybe we think about whether or not you chose wisely, and maybe we want to think about whether or not somebody else who's willing to step up and learn those things, one of the other kids or somebody else might be more appropriate. If they're not willing to put in an hour to learn what they're going to need to do in an emergency, then you might want to think about that and say, okay, love you, but if you can't commit to an hour to learn about what happens if you find out that I had a stroke, or once I pass away, then you might want to think about if there's other family members that could fill that role.
Yes, that's a great point. Thank you, Bob. So some of the most pressing questions that we get as a team, they're not just from successor trustees, but from clients just like you. Now, when you come to your meeting, we give you this big binder filled with all kinds of documents, all kinds of different papers, and what do they all do? So why do you use these? When do you use these? I know that I'm not an attorney, so I still even have questions about these documents sometimes. And I'd like to go ahead and pass the mic to Kelly, who is going to go through and talk about these with you.
Thanks, Savannah. So you all have that big binder, right? You got that from our office. What are those documents? What do they do? Having the documents is one thing. Understanding the purpose of them and why they're in that binder is a completely separate thing. So some common questions that we often get in our office is, well, I want to make sure my kids have access to it. What do I do with the binder? My spouse is in a nursing home and I'm afraid I'm going to lose everything. What documents do I need to have in place? What about healthcare decisions? If you're not able to make healthcare decisions for yourself, what document are they looking for? Or what documents in general are necessary for all of that? So let's take this time to go through a refresher or a recap of everything that is in your binder and how it can help you. So the first one we always start with is what we refer to as our lifetime documents. And when we're talking lifetime documents, we're usually talking about a power of attorney. Now, there's several kinds of powers of attorney. What we're talking about powers of attorney, we're typically focusing on two categories. So a financial power of attorney and a healthcare power of attorney. The financial power of attorney is making sure that if you can't get around to the bank to make sure your bills are paid or manage your assets or make sure your required minimum distributions are taken every year, that you have someone you trust in place to do those actions for you. Now, a durable power of attorney for finances can be effective in a couple of different ways. Now, if you've got them through our office, which I know you do, yours are effective immediately. So right away, your agents can step in place of you and handle those assets for you to make sure your bills are getting paid and that your money is stable. Now, our powers of attorney have that little extra thing because we've taken the time to make sure that you have a comprehensive plan. Now, your powers of attorney have these things called extraordinary powers, and no, that doesn't come with a cape, although you're welcome to wear one. The extraordinary powers are focusing on what happens if you need long-term care. Now, there's a lot of bad advice out there with respect to long-term care, specifically that there's that nightmare that everybody lives. I don't want to lose everything to a nursing home. Well, the extraordinary powers can help your agents do that type of long-term care planning to protect your assets to the greatest extent possible if you cannot do it for yourself. So congratulations on taking the step to have those extraordinary powers in your financial power of attorney. Now, what happens if you can't tell the doctors what you would like to have happen? That's when your healthcare power of attorney comes in. Your healthcare power of attorney is only effective once two doctors have determined that you cannot make medical decisions for yourself. In Michigan, you actually can't delegate authority to someone else prior to that. So you're in charge until the doctors determine that you can't make those decisions by yourself. That's when your healthcare power of attorney will step in. And as we've seen this year, having a healthcare power of attorney is paramount, especially with the ongoing pandemic, making sure that if you can't convey your wishes to the doctor, that you have the next best person in line to make those decisions for you. Now, in our office, we often get the question of how often we need to update your power of attorney. We recommend that you at least get it updated every 3 to 4 years, or at least have it looked at every 3 to 4 years to make sure that there hasn't been any changes in the law. As we've seen with the pandemic, there's been a whole slew of healthcare issues that have popped out of this. We want to make sure that your healthcare power of attorney sufficiently covers you to make sure your needs are addressed. Now, what happens if you haven't planned? Now, I've already mentioned you guys have taken a great step to have the documents prepared through our office, so you have done that hard planning. But what about your loved ones? What if they don't have anything in place? What are they looking at? That's when we're typically looking at a guardianship or a conservatorship. And it's important to note that both of these are court processes. So in order for this to be effective, you have to deal with the court system and everything that comes with it. A guardianship is typically going to be in place of that healthcare power of attorney. So if you can't make medical decisions for yourself, someone is going to be making decisions for you. But that guardianship is actually broader than that healthcare power of attorney. Your guardian has the ability to make decisions about where you live, who you visit, with and what kind of medical decisions you have. So it's a lot more authority that's placed on a guardian, also that gets the court involved in your business. So guardianship is necessary when you don't have a healthcare power of attorney in place and someone needs to make medical decisions for you. So again, you all have done that great step of making sure that you have avoided it to the greatest extent possible. Now, the financial side, we're looking at a conservatorship. So a conservatorship is when the court is basically keeping track of who's managing your money and how it's spent and how much of it is spent on certain things, which might be a good thing, but oftentimes it's not necessarily the way that you would like it to be spent. It's your money, you worked hard for it. You don't always want the court dictating that. So this is necessary when we don't have a durable power of attorney for finances in place. You can avoid it by making sure that you've appointed the people you trust to make those types of decisions for you. Both of these processes I've mentioned are court processes. That often means that they're more time consuming and they're more expensive. And every year, your guardian or your conservator has to go in front of the court to file paperwork or admit accounts, all things that we can avoid doing if we take the time to do proper planning. So this is kind of your worst case scenario. Let's try and live in the best case scenario and make sure that our loved ones understand the importance of this. Now, diving deeper into our estate plan binder, we're going to talk about the last will and testament. Most of you have a last will and testament through our office. It's important to understand, though, what a will actually does. I can't tell you how often somebody comes into our office and says, I've done a good job of avoiding probate. I have a will. It's important to understand that a will is a probate process. It is not effective any other way. In our office, we use the example of the funnel. So the funnel does a really good job of getting things from point A to point B without extra spillage, right? But it doesn't carry things. It doesn't transmit stuff. That funnel process to get things from point A to point B means you're going through a court process. So it's time consuming, it's expensive, and we can avoid it if we do some extra planning. A will is important to understand. A will doesn't control everything. A will only controls certain assets that have to go through that probate process. In Michigan, a probate administration by statute is required to take a minimum of 5 months. In reality, though, it can often be longer if you're not taking Melissa's good advice and getting some good direction.
Right.
The control, again, because it's a court process, it's going to be with the probate court, not necessarily with your family. And perhaps one of the biggest drawbacks of relying on only your will is that it's public. Anything that is filed with the court as part of a probate administration after your death is public. Now, what does that exactly mean? It means that anybody can go down to the courthouse and pull information on your beneficiaries, potentially the types of assets that they're receiving, which opens up your loved ones to scammers and solicitors. So it's not the worst thing, but it's not necessarily the best planning that we could do. Most of you in our office have this little red wagon, or what we call a revocable living trust. This is a great tool to avoid probate, but it only works for assets that you have properly put into your trust. And I know Bob's going to get in a little bit on that a little bit later, but it's important to make sure that you understand the binder itself is not a magic pill. It's not going to fix all of this stuff. We have to make sure that we put our assets in there. That will make it easier for your family in the long run to make sure that they've successfully avoided probate. Now, it's also important to understand what a revocable living trust does not do. It does not start a look-back period for Medicaid, so it's not an asset protection tool in itself. It's not going to protect assets from lawsuits or other creditors, but it is still a fantastic tool to make sure that you're getting things to your family the way that you want it to in the easiest way possible. Now, some of you have what we refer to as this generational planning in your revocable living trust, which is a fantastic gift that you can give your family to make sure that their inheritance will be protected from the unknowns in life. Now, in our office, we always use the example of our 3 children, Susie, Roger, and Danny. So Susie, our only daughter, is a sweetheart. She didn't marry so well, and her husband just isn't the brightest bulb. So if something happens with Susie, we want to make sure that all the money that we left with her doesn't go to your idiot son-in-law. And then there's Roger, who tries really hard. Roger started a business, It didn't work out. So now he's got creditors and judgments kind of leaning over him. We want to make sure that whatever you leave for him doesn't get sucked up by Uncle Sam or the other creditors or in a bankruptcy. So we want to make sure we're covering Roger. And then there's Danny, who's been disabled since he was really young. He's never really been able to hold a job, and we just want to make sure that he's taken care of. So how can we do that with this generational planning? Well, some of you are aware that there are these lifetime protector trusts in your planning. And what this can do is protect your kids from all of those possible scenarios. So in the event of a bad marriage that leads in divorce, you're not losing your inherited money to your ex-in-laws. In the event of bankruptcies or creditors knocking at your kids' doors, we can make sure that the money you worked hard to leave them doesn't get sucked up by those type of predators. And then in the case of Danny, where we just want to make sure he's taken care of, those lifetime protector trusts can make sure we're protecting what Danny has, as well as his government benefits, to help aid in adding to his life and not risk the possibility of him losing his health insurance or other government benefits that he relies on. Now, there's also some retirement planning that can be done with this, and Bob's going to get into that a little bit more later. It's his favorite topic. I don't want to sidetrack it. Now, some of you have even taken an extra step and gone further with this asset protection plan in your binder. This is, sometimes we refer to this as a lockbox trust or a special needs trust for your spouse. This is a comprehensive plan to make sure that we can protect your assets to the greatest extent possible, especially if we need long-term care in the future. This type of plan can also help you qualify for veterans benefits or that long-term care planning. That Medicaid program is what we typically talk about. It does have some benefits of protecting assets as well. Now, there are some very specifics to this, which is why it's important that if you have this plan, you understand how it works, or if you're interested in this plan and you want to learn more about it, that's what we're here to do, is to help educate you on how we can make your goals achievable, as well as get you set up in the best situation possible. All right, so I'm going to turn it over to Bob.
Thanks, Kelly. And before I pass the mic to Bob, I just kind of want to put the bug in your ear. If you remember, many of you, most of you have seen the emails and the letters that we've sent out about those legal changes that happened this year. I mentioned it at the beginning of the presentation too. So Bob is going to talk about those changes and the rest of this year's hot topics.
Okay, so let's get right into it. So one of the things that I know that people aren't a huge fan of is having to update their legal documents because of changes in the law, and that did occur this year. And so we did have an opportunity to talk to a lot of you, and many of you, we've seen you because you've come in to sign off on the changes to your documents because of this thing called the Secure Act. And so it's just necessary when, I think that some folks, when they got that letter, were a little frustrated because they said, oh, maybe I just did my legal planning 2 years ago, and now you're saying we need to update it. I jokingly, tongue-in-cheek say, well, would you rather have an attorney that tells you when you need to update your legal plan, or one that just doesn't and ignores it, and then it's not up to date? So it is one of those things that will happen from time to time. And so this is one where it was particularly important because it was a matter of how much taxes your kids are going to pay, how much Uncle Sam is going to get of your estate, and how much you're able to pass on. And as a general rule, most people would rather have their kids get the inheritance rather than the government or Uncle Sam. And the Secure Act has a big impact on that as how it relates to your estate planning. And so most of you needed to have updates to comply your documents, your legal documents, your trust, and other documents with the new law. We're going to come back to that in a second. And the reason I told you or brought all that up is because there might be another change soon. And I know you don't like that, so you're probably just like, oh my goodness, Bob, you just contacted all of us and made us all come in and sign off on this change. I think it's likely, and this one's going to be even more universal. Fortunately, it'll be less expensive of a change, but it's likely to be even more universal of a change. And I don't know for sure that it's going to pass, but I'm pretty darn sure it's going to pass. I don't know if it's going to be this year, or it might be next year, But within, unless something changes, and it doesn't matter who's in office. This is a state matter. So the state elections, the state politicians aren't going to change that much this year, right? They're going to change a little bit, but not a lot. I know on the federal level, everybody's talking about that, and we actually have a webinar coming up on how to invest considering the upcoming election. But the thing on this is the power of attorney changes are going to be state-based, and so it's not about who's in office because it's not going to change that much between now and next year. So as a result of that, I can say with a pretty high degree of confidence is there's likely to be a change. So Kelly had mentioned earlier about that our legal documents include these things called extraordinary powers. And not everybody. You have to have a high degree of trust. I always say you have to have somebody you trust and you love in order to do the best planning. You do. You have to have somebody you trust and you love. If you don't have anybody you trust or you love, then you're not going to get the best planning. That's just the way it is. And so when it comes to extraordinary powers, you have to have somebody that you really trust and that you really love, and they love you and they really trust you. But the bottom line is those extraordinary powers are really important in the event that you ever went into a nursing home, or your spouse went into a nursing home, parent goes into a nursing home, those types of things. Because those are that's the language that is in our documents, and most of our documents for people that have people they trust and love, that most lawyers don't put in there. And why do they not? Why do most lawyers not put those in there? Well, because they're extraordinary. They're extraordinary. You're giving extra authority to your kids that most people don't give to their kids. Now, we put restrictions on it. To be clear, we put restrictions on it to say you can only use these extra powers, this extra authority, in the event that we're going to lose everything if we don't have this authority. And in fact, if we don't have that, often we can go into a judge, and the judge will give that authority to the kids. So it's not, when I say it's extraordinary, it's not where it's not something you wouldn't want to do. It's something that even judges will allow us to do. But what we recommend for most of our clients is put it in your legal documents so we don't have to go into a judge. We don't have to ask a judge for permission. We don't have to get into a court process, right? And so those were those extraordinary powers are. Well, the state has been concerned, partially justified and partially not justified. So the state has been concerned that people could abuse those extraordinary powers. If you give extra authority to the kids, they could abuse that. That is a danger. That is a worry. And so, the answer is not to throw the baby out with the bathwater, right? The answer is not to ban extraordinary powers, which was one of the proposal. The answer is to say, okay, if we're going to put these extraordinary powers in there, we got to have some extra protections in there. We got to have some extra things there to make sure that it's that this is legitimate and it's not some kid trying to take advantage of a parent or steal money from a parent, right? And so it's a bit more complicated than this, but the proposal is that an attorney would have to sign off on it, saying that they properly counseled the family and things like that in order for those extraordinary powers to be valid. So not only the attorney signed off on it, but the language of the new proposed law would have to be included in your extraordinary powers. So that's a law that's likely to pass or so. That's going to put some that is going to make it so that if we have these extraordinary powers in your documents, that we have to probably update your documents to comply with these new protections. The government's, I'm from the government here, I'm here to protect you. I'm from the government, I'm here to help you. But these new protections, which are valid because everybody knows, we've heard about families where the kids took advantage of the parents and the kids steal the parents' money, stole the parents' money, and they might have used legal documents to accomplish that. So they're trying to put some protections in there to say, okay, yes, some people need these legal documents. Yes, people often need these extraordinary powers, but we want to have some checks and balances and protections in there, likely to mean that we're going to have to update your legal documents again. It should be a relatively straightforward, quick thing. Not anything like the Secure Act that we've had to deal with recently. It's not nearly as complicated. It's simply a matter of adding the new language, putting some additional signatures on there, and doing a little counseling. And that should be relatively quick and easy, but it does probably require most of you to come back in and sign off on updates. Haven't seen the final version of the law. Obviously, it hasn't been passed yet, so we can't see the final version of the law. As far as whether things will get grandfathered in, but I'm thinking that it's best to be safe than sorry and make sure that if they put additional restrictions on extraordinary powers, that we comply with that for all of our clients. Let me recap one last time as to why we want those extraordinary powers. This is the difference between having to lose everything if you go into a nursing home and not lose everything if you have to go into a nursing home. It's the difference between us being able to help the family and help the spouse to be able to not, have the house subject to a state recovery, so potentially lose the house, or having to spend down all the money without having to run into court and worrying that the court may say no. So it is important. It's a big part of our practice is to counsel people about these extraordinary powers. We've used them successfully. I've been doing this for 25 years. I've not had any knowledge of anybody abusing the extraordinary powers that came through our office. Okay, so it's an important element. We've got to have some checks and balances and protections in there, but it's going to be something important. We'll let you know when that changes. So it may be this year, maybe next year. Don't know, maybe never, who knows, but certainly we'll let you know if those are updated, and it'll be a quick and easy change. It won't be very costly, but it's likely you're gonna have to come back in and sign, which goes to the next one, remote signings. So some of you that follow us on the computer and follow us on the social media, Facebook and all those things, may have seen a video that I did back, I guess it probably would have been April, you think?
Yeah.
Where I was excited because once they shut down the state back in March and April, when they shut down the state, it made it very difficult for us to help people because legal documents in Michigan have to be signed in front of people in the same room as people. The law is very clear on that. The notary and the witnesses have to be physically in the same room, or at least in the same line of sight, and be able to hear and see. And that was impossible during the shutdown, right? It was impossible, at least to comply with the law and have that. So we were very happy, and I posted a video expressing my happiness that we got an executive order that allowed for remote notarization and remote signings, and we took advantage of it. I think we had 40, 50 people that were able to get documents done that wouldn't have otherwise been able to through our office. Me and some of my friends and colleagues had recognized this as being a very serious issue very early on, even before the shutdown. In fact, I was, these guys will remember, prior to the shutdown, when there was rumors of the shutdown, I was constantly getting phone calls and text messages from all these other lawyers saying, what are we going to do? What are we going to do? And so I was both appointed and volunteered to help organize the committee that reached out to the governor, and our section of the Lawyers Association, our section of the bar, was very instrumental in not only getting the governor to sign that executive order, but framing it, but wording it in a way was going to be useful and helpful. And I was on a committee nationwide of other lawyers throughout the country, and what their governors were doing and what their Supreme Courts were doing and what their legislatures were doing. And honestly, Michigan had one of the better ones. I'm not saying anything about any of the other executive orders. That's up to you. I don't have anything to say about that, but this particular one, we were able to have influence, and we were able to get an executive order that was much more workable than most other states had. And so we were very excited about that. Well, we had that for several months. It went through, what was it, September, I think. It ended in September. It's not anymore. The Michigan Supreme Court set aside all the executive orders, and so we cannot do remote witnessing or remote notarization anymore. So we have a meeting coming up soon that's going to be where the person, our client, is going to be driven here in their car, and they're going to stay in their car in the parking lot. We're going to go out to the parking lot. We're going to see them. We're going to sign the documents, notarize the documents in the parking lot, so they don't even have to come in. We're going to keep the social distancing, the masks, all of that. We have another one where the person is confined to a nursing home, And we asked the nursing home, is it possible if we have clean our hands and wear the mask and do all that, can we come in and sign? They said no. They said, well, can we stand outside their window and notarize it from outside their window? And they said yes. So we're going to be doing that in a few days here. We're going to do whatever we have to do to make this happen. On the side, we're working with some key legislators to actually get a law passed. So we're not relying on the governor or executive orders. And so we're working hard, and we're excited about the possibility that we could get that law passed, allowing for safe remote signings that are also going to preserve, to make sure that people aren't being taken advantage of, and that they really are intending to sign, and that all the safeties of making sure people aren't signing things that they don't know what they're signing. Those are all still going to need to be in place, but we're working with some key legislators to try to get something passed to make this more permanent. Again, could come this year, could come next year, but as of today in October 2020, we are not able to do remote notarization or remote signings, but we'll work around it. We'll figure out some other way. What we are able to do, and we've very much taken advantage of, and this isn't a perfect example of that, is having remote meetings. So in the past, we always had to get together, and you guys would come in, and we would videotape it for those that didn't want to come in, but we'd have a huge room, huge ballroom, and we'd have cider and donuts, and we'd all get to see each other, and I'd introduce you to new team members, and we'd get to say hi and have some coffee and donuts, and then we would do our meeting in person and videotape it for those who couldn't come. This is an example of a remote meeting now. So now we're all having to learn some computer technology and computer issues to make sure that we can do this. So I'd say the majority of our meetings, where it's a consultation, or we're drafting documents, or we're gathering information, at least half, I'd say lately, have been remote, where we are both sitting at our desks, or sitting where you can use your phone, you can use your computer, we can just use the phone. All of those are possibilities to maintain the social distancing and be able to make it as convenient and safe for you as possible. So we've, for those that do come into the office, because our office is open, absolutely, and so we are definitely doing in-person meetings. Also, for those that prefer in-person meetings, we do wear masks. We're not wearing masks today because we decided for the video we weren't going to do that, but we do wear masks whenever there's a client in the office. And this table actually has this big sneeze guard that we put on it, and we took it off for today just because we didn't want to block the video. But all of our offices that we meet clients in actually have a barrier, a physical barrier with a little hole in it where you can shove documents through and things like that. So we're doing all the things. We're following all the rules, and we're making it as safe as possible. And we can absolutely meet with you in person at both the Rochester Hills office and at our Grand Blanc office, and then anywhere else, because we can do it remotely. We can do it over the phone or over the computer. So remote meetings. So that's how we've adapted, and we honestly, I'm just so proud of our team and how quickly we adapted. It was really amazing how well people stepped up to make sure that we could still help people, we could still stay in business, and we could still, get, when people had an emergency, we were going to be there for them to help them. So as far as COVID-19, obviously there's all kinds of things that are changing, both the way that legislation is done and the politics of everything. So keep an eye open on this, and if you do email, this might be a good time. If you haven't done email too much in the past, or if you're not on our email list, it might be a good time to get on our email list, because we are keeping people informed on a quicker basis. If you're on our email, if there's a change in the law or something, one of the things that we've been sending emails about recently is, what if you have a loved one in long-term care? What if you have, can you visit them? What are the rules for visiting them? And those have changed quite a bit. And if you can't visit them, what can you do to make sure they're getting good quality care? And so we sent out a number of things on that and the changes. So if you are inclined to be on our email list, there's a lot of real valuable information lately. And we've been doing these webinars. So ever since the shutdown, I decided to sit in front of a computer every Wednesday and talk for however long I need to, typically less than an hour, sometimes half hour. I'll try to get less long-winded and make them even shorter, but talk about important topics that are going to be of interest to you. So every Wednesday, and then you can watch the replay. Those are posted on our website too. So if you're not available at 2 o'clock on Wednesdays, don't worry about it. They're all the replays are posted. And we've probably got, I don't know, 40.
Yeah, I think around 40.
Yeah, and so you might want to just scroll through that and see what topics we have there. And if there's one of interest to you, then maybe, consider watching it. So the Elder Abuse Task Force is interesting. So the governor and the attorney general started this task force to deal with elder abuse, but particularly guardianship abuse. It was one of the things that they really focused on, and that power of attorney law that we talked about a few minutes ago, that's coming out of the task force. But they're really focused on making sure that public guardians are not taking advantage. It's very difficult. It doesn't seem like it would be a difficult issue. But the more I've looked into it, because I've never been a public guardian, we don't recommend using public guardians. We don't, sometimes it was necessary for a handful of our clients because there was no other option, but we really, try to make sure that we have, loved ones or competent, family members or people that you love and trust that are involved if you can't make decisions for yourself. So we didn't have a lot of involvement in the public guardianship issue, as a lot of attorneys do, because a lot of attorneys will just run into court and say you should get guardianship for everybody and get a public guardian. So most of our clients didn't have to deal with this unless they didn't come to us until it was too late, and then a public guardian had already been appointed, and we had to deal with that. But there was a lot of a lot of bad things going on. And last year, if you came to the annual meeting last year, I talked about a number of cases. There was one that made a lot of news where there was a family member ready, willing, and able to be appointed as guardian, and the judge in downstate somewhere had appointed a private, not a public guardian, who then hired their own company to provide 24-hour care, hired their husband, who was a lawyer, they spent like $400,000 in 6 months of this family's money, all, passing it around in their own family or to themselves and to their own companies, and locked out the family and all kinds of, bad stuff, if you ever heard about that case. And that's not the only case. That was a pretty extreme version of that case where a public guardian kind of took advantage. Well, recently that case was settled. The attorney general and others were involved in that case. The case was settled, and the public guardian that was appointed and the caregiving company and the lawyer that was involved in that have all been banned, or they've signed a settlement saying they will never act as public guardian again. So in that particular case, there's some resolution, but my answer to all of this, obviously, great, let's improve the law. My answer to all of this, do planning, think ahead, get some things in place, come in and consult with us. We'll make sure everything's in place so that we don't end up in a situation where a judge is appointing a stranger, okay? And then finally, let's talk about the Secure Act. So this is, many of you have already had this conversation, and I just want to go through it one last time. Why did we make such a big deal about the Secure Act? Well, first of all, it's only about retirement assets. So if your only asset is your house and a bank account, you probably don't have to worry about this, right? This is only about retirement assets. Well, how do you know if something's a retirement asset? Well, if it was part of a 401k from work, or if it used to be part of a 401k from work, if it was a rollover IRA, an IRA, a Roth, qualified annuity, a TSP, any of the programs provided a buyout. So if you took a buyout, you had a pension through GM or Ford, and you took a buyout, that's a retirement asset. If you're over now 72, but before 71, and you had to take required minimum distributions, you had to take distributions out every year, that's definitely a retirement asset, okay? There's a number of ways to determine if it's a retirement asset, but it's those things that we either haven't paid taxes on fully yet, or has tax advantages like a Roth, where you don't pay taxes on the growth. Those are the accounts that I'm concerned about. And the law changed pretty dramatically because we used to be able to, and a lot of you took advantage of this with our legal planning, stretch out the taxes on that for the next generation. So the kids could choose not to pay the taxes on it right away and stretch it out over their whole lifetime, or maybe even have it go on to the grandkids and stretch it out. Well, you have $100,000 stretched out to a grandkid who is 20 when you pass away. It goes to a grandkid, and they get to stretch it out for 60 years. $100,000 would be well over $1 million that they've collected off of that, over that period of time if it was invested properly, and we get the tax advantages. Well, that's a little bit thrown out the window because they came up with the Secure Act, and the Secure Act says that for a lot of folks, we're going to have a 10-year time frame for paying the taxes on it. But that's not the final answer. And so I saw this, I didn't come up with it, I saw it, this red, yellow, green, so the stoplight approach, and I keyed in on this because I think this is the best way to describe it. We can set up your legal planning to say, okay, if we can qualify for the green section, which is called an eligible designated beneficiary, and the trust and your legal documents incorporate eligible designated beneficiaries, we can get more money to the kids, have them pay taxes over a longer period of time, probably pay a lower rate of taxes, or with a Roth, be able to get huge tax advantages and tax savings of not having to pay taxes on the growth over a longer period of time. And that can extend, just like we said before, possibly 60 years or more with these eligible designated beneficiaries. They came up with a new category, chronically ill. Well, do you have any chronically ill beneficiaries? Don't answer that because you don't know if you have any chronically ill beneficiaries. How do you not know? How do you not know if you have any chronically ill beneficiaries? And the answer is the word beneficiary. You don't know who your beneficiaries are. Why don't you know who your beneficiaries are? Because you're not dead. You don't know who your beneficiaries are until you die. And that might be 40 years from now, 50 years from now, or it might be tomorrow. We just don't know that. And we can't define our beneficiaries. We don't know who our beneficiaries are and what their circumstances are until you die. So what we've set up is a plan that would be able to categorize them to get the best possible tax advantages once we have all of that information. What we don't know right now is when you're going to die, how much money you're going to have in retirement assets, who your beneficiaries are, whether or not they might want to pass it on to their kids. So one of the big advantages that people have taken to add this Secure Act language to their trust is to say, okay, well, when I die, and that might be tomorrow or 50 years from now, my child may be in a position that they would be better off bypassing themselves and having this asset, this IRA, go on to their kids. Why would anybody choose not to take the money and have it go on to their kids other than just because they love their kids? Well, there's some real important strategic advantages to that. One is that the grandkids would probably be in a lower tax bracket. Okay, so wouldn't it be great if we could pay lower taxes, be in a lower tax bracket, have it go on to the grandkids, and then so your daughter Susie says, I don't really need the money. I'm in a high tax bracket. I'd like to pass it on to my child who's 16 and have them pay it at their tax bracket. Can we do that if we add the Secure Act language to your plan? And the answer is absolutely yes. Now we got a huge tax advantage, way more money going to the family. Now, anybody see the flaw in that 16? Do we really want a 16-year-old to have $100,000 at the discretion? No. So we get Susie and we say, okay, Susie gets to still be in charge of that money. So it gets taxed at granddaughter's tax bracket, but Susie gets to still be in charge of it because you're deceased, right? You've already passed on. Susie gets to be in charge of it, but it gets taxed at her child's tax bracket and can get doled out to her as appropriate. It doesn't, the granddaughter doesn't get it when she's 16. She doesn't get it when she's 18. She gets it as her mom says she gets it. But we still get to tax it at the granddaughter's tax rate. So these are just examples. What we really want to avoid is that red column, the non-designated beneficiary. And what I worry is some of you, if you don't do the update and you have retirement assets, you might fall into that red column. So we've got two answers for you on this. And this should have been all discussed with you, but this is kind of a recap. If you have retirement assets, you've got two options. There's only two options, A or B, two options. you either get the update, come in, add the update to your legal documents, or you bypass your legal plan altogether and you list the kids as beneficiaries directly. You bypass the trust. You do not list the trust as beneficiary on your retirement accounts, your IRA and such, unless you get the update. If you don't get the update and you still list the trust as the beneficiary or contingent beneficiary or anything like that, you potentially have a tax problem. So that's it. I know that seemed like a lot of information, a lot of details, but it really comes down to A or B. Either get the update, which I recommend for most people if you're going to get if you have retirement accounts, IRAs and things, or decide, no, I'm not going to pay a little bit to get the update, but then I'm going to have to bypass all of this and bypass the protections and bypass the protections from divorce and bankruptcy and creditors and the possibility of passing it on to the grandchild while still maintaining it and all those types of things. So just give it some consideration, even if you already thought about it. If this maybe explained it a little bit better, hopefully it did. All right, one last thing before we get to our memory jogger. The memory jogger is the thing that everybody kind of waits for, and we'll get to that in just a second. But I just want to remind everybody, so many times we have longtime clients that come in and their kids, and maybe they didn't talk to their kids, but their kids say, oh, mom has to go and get 24-hour care. And so I was told by the social worker, I was told by the nurse, I was told by the banker, I was told by my neighbor, I was told by my barber that we're going to lose everything, that we're going to have to spend down all of my assets. I might lose my house. And the answer is no, 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 no. But you need to call us. If that happens, if there's a massive stroke, if there's a fall which requires continuing care, if you're going into assisted living, going into nursing home, if you're in the hospital and they say you need rehab, then you're not going to get to go home right away. You're going to want to call us immediately, okay? That's when we can help you make sure that you're not going to lose all your money and not going to have to spend down everything. Or private pay for 3 years, lose most of everything, and then call us. That's okay too. It's just better if you called us 3 years earlier. And it's fine. And what I'm saying is you don't have to call us in that crisis, but that's the best time to call us, because then we can help you make sure that you're going to leverage what you have, to make it much less likely that you're going to have to do any kind of spend down or spend down more than you have to. Let's put it that way. All right. So one of the key things to our annual meeting has always been our memory jogger. And so the idea of the memory jogger is we're going to ask you a series of questions, and hopefully you have this. That would be, it's available for download. We did not put it on the dashboard here, so they can't download it here, but it would have come. You will get it because you'll get an email if you're on the call, or even if you just signed up for the call or this video, you'll get an email today or tomorrow, and attached to it will be this. It also would have come in the mail, right? We would have sent this to you in the mail. So this is, we're going to ask you a series of questions, and this is our way of helping you sort of do a self-study of, do you need updates? Do you need changes? Okay, so we're just going to go through them one by one. If you, what we'd recommend is you turn this in, you send this back to us. You can turn it, there's two ways to turn it in. You can mail it back to us, or we have a fillable one and you can email it back to us. So we sent you in the email that you would have gotten for this, there was one that you can just click the box on the computer and then email it back to us. You just email it at info@manorlaw.com. So let's go through it. Financial assets. Have you switched banks? Did you get a new credit union? Do you have a new financial advisor? Did you open up new CDs? Do you have a new mutual fund? Did you change your life insurance or other investments? Why does that matter? Why does that have anything to do with it? Well, the answer is, this is what Kelly was talking about. You got the wagon. We got to make sure everything goes in the wagon, okay? Whether it be where we're changing ownership to the trust or we're changing beneficiaries, but one way or the other, we want to make sure everything goes through the trust, goes through the wagon. And so if you got new stuff, you might want to let us know. Now you're going to check yes if you have. If you haven't, you check no, and that's fine too, okay? But if you check yes, what's going to happen? Well, you're going to send this in, and we're going to call you, and we're going to talk it over the phone, and we're going to decide what you need to do next. Okay. So any yes marks, that just means that when we get this back, we're going to call you and see what we need to do. All right. Has there been any significant births, deaths, or disabilities? So do you have a new grandchild that has autism or Downs or something like that? Well, we've already put some planning for that, some generic planning in your documents for everybody. If you've done documents, we've kind of pre-thought that out, but it's probably worth at least a conversation. So it might be worth a consultation to say, hey, I've got a grandchild now who has Downs. Is there anything that I should be doing differently about my planning? If your spouse died, clearly let us know. If one of your kids died, it might be worth a conversation, okay? Is there change in your health? Okay, have you been diagnosed with any of the dreaded diseases? Probably a good idea to let us know. I put in the agreements that where you what we call them the retainer agreements where you hire us. I put in those for years to say if something bad happens and you call us, we're not going to charge you anything for that phone call where you tell us something that bad happens. And I always joke and say, well, you can call us when good things happen too, but we really do need to know when bad things happen. Okay, that's what we're here for. And so if you've got a diagnosis of Parkinson's or dementia or Alzheimer's, or if you've had a stroke, that's probably something we need to know about. Even if there's no legal changes right now, we probably should at least know about it, because there might be something that we say, okay, well, after you told us that, we looked at your plan and we think you might need to adjust it a little bit. So if something bad happens, let us know. Okay, so you'd mark the yes on that. Changing your marital status, obviously, we would want to know about that. Did you buy or sell other real estate? That's important. Many of you, as you sell real estate, you know that the title company typically wants something called a certificate of trust, existence, and authority. That's something that if you give us proper notice, we can get it to them ahead of time. So we like you to give us a week's notice before you sell property. If you buy property, if you tell us before you buy it, we can make sure that when you buy it, and it'll be included in the trust. If you forgot to tell us, you're going to check yes, and then we're going to want to make sure that that gets in the trust, and that's something that we're going to have to do. So you're going to want to check yes on that. After the discussion today, do you feel that your assets are not properly in the trust? So this kind of goes back to Kelly's discussion about putting everything in the wagon. So if we went through every single asset that you have and you say, you know what, my checking account's not in the trust. You know what, my mutual fund's not in the trust. You know what, I have this Florida property and it's not in the trust, or I'm concerned about it. Check yes, we'll call you and we'll work through that, because it's important. This doesn't work unless we put everything in the wagon properly, okay? And then do you have any other concerns that you'd like to discuss with us? And we give you a couple of lines just to kind of write that out. And what we'll do is we'll then schedule a time, or we'll call you and kind of talk you through it. So we do have, and Savannah's going to talk to you about this, but we do have a little prize or incentive. We're just going to put everybody's name in the hat and draw a name to make sure that people turn this in a timely fashion. So we'd really like you to get this back to us by Friday, November 6th, which is not next Friday. It's a week from this Friday.
Yes.
So, all right, so I'm going to turn it over to Savannah. She's going to talk you through all of that. But the one thing I'll put a little plea out there for you. You know, I'm really proud of the team that we have here and the work that we do here. And I know that a lot of you are real happy with the work that we do. And so I would ask, you know, this is kind of a strange time, and we don't know what the future looks like. And we are as adaptable as anybody. We are as agile as anybody to make sure that we're going to adjust to the changes in life, and that we're going to adjust to the changes in politics and the changes in law. And we'll be here for you, and we'll be you know, helpful to you as things change, and especially if things, you know, if there's any bad things or crisis that occurs, we'll be here to help with making sure that you've got the care that you need, that your plan is set up properly, that it complies with the law. And you know, we really appreciate everybody saying nice things about us. The nicest thing that you could say about us would be to tell a friend, to tell your kids, hey, you know, these guys they're serious. They're gonna follow through. They're not just gonna have you come in and sign something and never talk to you again and have you write them a check. We're going to follow through. We're going to be there when the law changes. We're going to be there to let you know when something happens. And we're going to be there for you when a crisis occurs in your life, so that we can address the legal issues and have you pre-prepared for that. But even though you're pre-prepared, we're going to be there when the time comes too, to be able to help you figure out, okay, how do we get care? Where are we going to get care? How are we going to pay for care? All of those types of things. And the key on this all is that if you appreciate our services, tell people about it. I would really appreciate it. It's important in this time, and we are able to help lots of people now, especially now that we've learned to do everything remotely. We can do it even from a little further away. So as long as they're in Michigan, they do have to be a Michigan resident, we can help folks. So I would really appreciate if you can pass that information along. And Savannah's going to kind of tell you about a little incentive that we have for you too.
Yeah, thanks, Bob.
Yep.
So before we get to the incentive, I do just want to remind you that there is a prize for the memory jogger when you turn it into us on the 6th. We are going to draw all of the returned memory joggers, and one special person will win a fall-themed basket designed by yours truly. I'm really good at gifts, so you do want to win this basket. So definitely get that into us. As Bob mentioned, I will be sending out an email probably later this afternoon, just to get it out to you as quickly as possible. It'll have the replay of this meeting, and most importantly, it will have the memory jogger attached. You can download it right from the email and turn it back to us online. It's also on our website right now, so where you went to go register on our website, themanorlawgroup.com/annual meeting. That's there too. You can download it from that page. It was sent to you in the mail, so you're welcome to fill it out by hand and mail it to us. Or if you're close to the office, you're more than welcome to just stop by and drop it off with your mask on, of course. So yeah, I do encourage you to get that into us as soon as possible. Now, as Bob also mentioned, a referral from you is the highest compliment that we can ever get from you, and we would appreciate that so much. So if you do have a friend or a family member or a coworker or anyone that you think of that may need our help, we're actually giving a little incentive to them. So as you see on the screen, we have this, I'm going to call it a gift voucher, gift certificate. But if you're a special person, calls us to schedule their time or just to talk with us, and they mention friends and family, they actually will receive $100 off their estate planning services. This is valid until January 31st, 2021. So they don't have to actually print out this coupon. If they want to, you're more than welcome to, but they can just call and mention friends and family. So you can give this to as many people as you want. We're not capping it. We're just saying it expires on January 31st. So again, we do encourage you to pass the word along, and we sure appreciate it, and we know your friends and family would too. So now is the time where we can go through any questions that you have. If you do have a question, you haven't already put it in the question box. This is your last call for those questions, so go ahead and drop those in. I know we have had some questions, and Katie so graciously has been behind the scenes collecting them for us. So I'm going to go ahead and read some of those questions that we have now. So the first one, what is a quitclaim deed?
All right, so there was a little confusion on this on one of the webinars I did recently. I had a realtor and a title company, and we were kind of talking shorthand between us about how quitclaim deeds can be misused, and we were saying how bad quitclaim deeds can be. And that doesn't mean that they're always bad. We use quitclaim deeds as part of your trust, but the idea of a quitclaim deed as to add the kids' names to the property is almost always a bad idea. Almost always a bad idea to add your kids' names to a property. Now, I know your parents might have done that. Laws have gotten harder. Circumstances are gotten more difficult. It may have worked when with your parents. It may not have worked as good as you remember it working, but it can create all kinds of issues. And so the idea is quitclaim deeds they're way more complicated than you think. It's not a user friendly thing. It's not a do it yourself process. So it doesn't mean you can't have a quitclaim deed. It means you better have it reviewed by a good attorney, which is us. Have us review it. So.
The next question, do I need a ladybird deed?
This is something that comes up all the time, and I'll have Kelly kind of answer this, but we get this all the time that we've done this planning for years, and we do very thorough planning, and then we'll get one of our clients that will say, hey, I went out to breakfast with my best friend, and she said, you're crazy if you don't have a ladybird deed. And we don't have a ladybird deed with you, so why? My friend calls me crazy. What's going on?
So ladybird deeds are a tactic, and they're just exactly that. They're a type of deed. Typically, they're done for a very narrow purpose, and that's typically to avoid probate. So you can avoid probate and run into umpteen other pitfalls or mistakes with a ladybird deed. So basics of a ladybird deed is you're basically listing who you would want to have the property transferred to upon your death. So it's kind of like a beneficiary designation, but there are a lot of pitfalls involved in that. Who you transfer it to, how you transfer it to it. Do they all get along? Are they going to be able to sell it afterwards?
Would they die before you?
Did they die before you? It becomes very, very complicated if they are not done for a very specific, well thought out process. So they do work to avoid probate. There are a million other tactics that can be done to avoid probate that are much better planning and much more comprehensive. The other thing that the ladybird deed is not going to get you is all of those trust protections that we talked about. So the trust does a lot of other things besides get things from point A to point B. It has backups, it has flexibility, it can adjust for change in circumstances. A ladybird deed is not going to do any of those things.
So just to tack onto that, you've got a better answer.
Mm-hmm.
So when your friend, you go to breakfast with your friend and they say, well, my lawyer said I had to have a ladybird deed. We gave you a better answer than the ladybird deed. And so a lot of lawyers are really, frankly, this is what we do for a living. This is what we think about at least 40 hours a week. And so if we don't do criminal law, we don't do bankruptcy, we don't do all the other stuff, we do this. And so we've thought this through and we have better answers than just kind of the flip it, hey, do a ladybird deed, okay? So your answer that you've got is better than what your friend has, frankly.
Yeah, great question. We had another question come through. Someone says, I bought my home out of state. It is titled in our estate name. Is it in the red wagon?
Yeah, I'm not sure exactly what that means. It's probably one of those things where you should check yes on your memory jogger, and then we can call you, and then we should look at the deed. Really the only way I'm going to answer this is I have to look at where you bought it and what that deed says, because maybe it is and maybe it isn't, but it doesn't hurt to have us look. And I'll just send it to us and we'll look, and then we'll call you and tell you whether or not it's fine or you might need us to fix it. And by fix it, mean make sure it's in the wagon.
Another question, how much in IRAs do I need to have to worry about the Secure Act?
Well, it's a great question. And you want to give the typical legal answer for every question?
So the one answer that everybody loves to hear from a lawyer is it depends.
It depends on so many factors. That's why we have this whole process in our office about talking to our clients about the Secure Act, where we had a 15-minute phone call and then we had a follow-up meeting. We had all these other things. And it was because it's really going to be a case-by-case basis. We have to look at how much you have, how old you are, how many kids you have, what the situation of the kids are. You know, if you have a smaller amount but your kids are on disability, that's going to be a different answer than if you have a larger amount and the kids are millionaires. Everybody, it's kind of a case-by-case basis. So that's why we're allowed clients a free 15-minute sort of meeting with somebody in our office that could help walk them through that, because there's not, unfortunately, I can't give you a set number for that question.
Excellent. Another question, if I already have a trust, why do I need a will?
So it's simple. The will there is kind of a catch-all. We always do a will whenever we do a trust, because simply if we don't do one, the state of Michigan does one for you, and it's probably not the plan that you want. The wills that we do are always done in conjunction with the trust. So think of it as a safety net kind of under your little red wagon. So if something falls outside of the little red wagon, our wills are designed to catch that like a bucket and dump it through the trust, because your trust has all the good stuff in it. It has all that flexibility and those adjustments. So we always do a will in our office whenever we do a trust for you. It's very simplistic. It is designed to protect your privacy and serve kind of that bare minimum purpose to catch things that fall outside of your trust. So we always do a will whenever we do a trust.
And then unless Katie has another question, this will be our last question today. Can my kids use my DPOA to sell my house or close my bank account after death?
I'll take that, Melissa.
Sure. It's a common misconception that the power of attorney is going to give whoever has been appointed just power to proceed. But something to remember is that it ceases at death. So if the durable power of attorney is the only document you have, they will not be able to use that after you pass away. We're going to need assets in a trust where the trustee can step up, or hopefully not have to go through a probate estate and get letters of authority. But no, the power of attorney will not work after death.
So one last reminder, don't forget to fill this out and send it in. This is our way of knowing that you were here and that you've thought about this year. And if there's any yeses, then we'll follow up with you.
Thank you everyone for attending today. And hopefully next year we'll be in person, but if not, we will make sure that we're here for you every day of the year.